Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. Have you ever clicked, I have read and accept the terms and conditions without reading a single word? Of course you have. We all have. The reality is that most people only start reading the small print when something has gone wrong. The goods are defective, the service was poor, the delivery never arrived, and that's usually when they discover a clause saying, we accept no liability, or liability is limited to £50, or we are not responsible for any loss arising from this contract. So today's question is, can a business actually rely on that clause? Because the answer is often, not necessarily. Let's find out why. Now, exemption clauses are clauses that seek to exclude liability altogether or limit liability. Businesses use them because they want to reduce risk. Customers dislike them because they often reduce protection, and the law, therefore, tries to strike a balance. For SQE purposes, whenever you encounter an exemption clause, there are three questions you should work through. First, is the clause part of the contract? Second, does the wording actually cover the breach that has occurred? Third, does statute allow the clause to operate? If the clause fails any of those three stages, it will not protect the business. So stage one, is the clause part of the contract? Now, before a business can rely on a clause, it must be incorporated into the contract. Incorporation simply means, has the clause successfully become part of the agreement? And this should feel familiar because we've already covered it in our video on contract contents. Now, the easiest way to incorporate a clause is through signature. The general rule is brutal. If you sign it, you're bound by it, even if you didn't read it, even if you didn't understand it, even if it was hidden in pages and pages of terms and conditions. There are a few exceptions though. For example, if the clause is illegible, if the clause has been misrepresented, or if the clause is particularly unusual or onerous and has not been properly highlighted. But generally speaking, signature equals incorporation. Now, what if nobody actually signed anything? Now, the question becomes, was reasonable notice given? And the court considers factors such as timing, visibility, presentation, prominence, and critically, notice must usually be given before or at the time of contract formation and not afterwards. Now, why is timing important? Well, imagine buying something online. After you've paid, an email arrives containing an exclusion clause. This is clearly too late. The contract has already been formed. The business cannot slip new conditions into the deal after the event. Also, the more unusual or harsh a clause is, the more steps a business must take to draw attention to it. So think about it logically. If a clause removes an important right, the law expects the customer to be warned clearly. The harsher the clause, the more obvious it should be. Finally, terms may be incorporated through a previous consistent course of dealing, and this usually applies where businesses have traded with each other repeatedly over time. If they've contracted on the same terms over and over again, the courts may assume familiarity with those terms. Now, whenever you see an exemption clause, start by asking, did the clause actually become part of the contract? Because if the answer is no, the argument ends immediately. The clause cannot be relied upon. But then we come to stage two. Does the wording cover the problem? So we have to suppose that the clause is incorporated, but this does not automatically mean it works. We now ask, does the wording actually cover the breach and loss that occurred? And this is known as construction or interpretation. Now, the common mistake that students make here is they assume there's an exclusion clause, therefore the business wins. And that is not necessarily the case. The wording matters enormously. The clause must actually apply to the specific situation. Now, this is something known as the contra prefatory rule. If the wording is unclear or ambiguous, the court usually interprets it against the party seeking to rely on it. This is this principle of contra proferentem. Don't worry about the Latin, just remember the practical effect. If a business wants protection, it must draft the clause clearly. Any uncertainty is likely to count against them. Now, this is particularly important in negligence cases. If a business wants protection against negligence claims, the wording needs to make this clear. The court will not assume that negligence is excluded unless the language genuinely supports that conclusion. Now we reach the most important stage. Even if the clause is incorporated and the wording covers the breach, the clause may still fail because of legislation. Now, the statute that will apply depends upon the parties, and for SQE purposes, there are two main statutes. Either the Unfair Contract Terms Act 1977, which applies to business contracts, or the Consumer Rights Act 2015 for business to consumer contracts. Now let's start with the Unfair Contract Terms Act, UCTA. A common misconception is UCTA bans exemption clauses. It doesn't. Many exemption clauses remain perfectly valid. What UCTA usually does is subjects them to a reasonableness test. So the key question is, was the clause fair and reasonable when the contract was made? Notice the timing there. We're looking at the position when the parties entered the contract, not with the benefit of hindsight. Now, what factors matter? Well, the courts will consider things like the relative bargaining strength of the two parties, the availability of alternatives, any opportunities to negotiate, the visibility of the clause, previous dealings, and also insurance arrangements. There is no one single decisive factor. The court looks at the overall picture. Now, what can never be excluded? Well, one rule is particularly important. Liability for death or personal injury caused by negligence cannot be excluded. Not if the cause is reasonable, not if both parties agree, it simply cannot be excluded. And for SQE purposes, that's a rule really worth remembering. Let's move on to now look at the business to consumer contracts instead. This is where the CRA 2015 comes in. Consumer protection is generally much stronger than business protection. Why? Well, because consumers are usually in a weaker position. So many key consumer rights cannot be excluded at all. These include rights relating to satisfactory quality, fitness for purpose, correspondence with description, and reasonable care and skill. A trader cannot simply write these protections out of the contract. The law simply will not allow it. So whenever you see a consumer problem, ask, is the clause attempting to remove a statutory consumer right? If it is, the answer is often very straightforward. The clause is not effective. One final twist here though. Can an exemption clause protect somebody who isn't actually a party to the contract? Well, historically, the answer was no, because of the doctrine of privity. But modern law allows third parties to benefit in certain circumstances. For example, named individuals, employees, clearly identified groups. And if the contract makes it clear they are intended to benefit from the clause, protection may extend to them as well. So what's Bowdie's bottom line? Every exemption clause question comes down to three stages. Firstly, is the clause part of the contract through signature, notice, or previous dealing? Second, does the wording cover the breach and loss? Interpret the clause carefully. Any ambiguity will usually count against the party relying upon it. Thirdly, does statute allow the clause to operate? and use UCTA 1977 for business-to-business contracts or the CRA 2015 for consumer contracts. And remember, an exemption clause must clear all three hurdles. If it fails incorporation, it loses. If it fails construction, it loses. If it fails statutory control, it loses. And that's the framework that will solve the vast majority of SQE exemption clause questions. As always, thank you very much for watching this video from the Bowdie Short series. Please continue to watch the other videos in the series. We hope you find them helpful.